May it please the Court, my name is Edmonds, EDMONDS, initials AE, and I appear for the defendant, Dr. Kale. Your Honour, may I commence by making the point that the applicant, Tedwood Constructions, provides that my client, Dr. Kale, has breached the relevant contract regarding their agreement about the constructions required to upgrade the flooring in Dr. Kale's home. The applicant claims that this breach is that Dr. Kale has refused to pay for the work completed so far in the house, as well as the full contract price of $16,000. Furthermore, disallowing the applicant to complete the rest of the contract they had originally agreed to. It follows that the applicant declares that he is entitled to claiming the full price of the contract in damages. However, I would like to focus on one of the terms that were clearly communicated before the contract. Your Honour, both parties have expressed that Dr. Kale communicated to Tedwood Constructions that the flooring was to be made out of genuine wood made from the tree known as the honey ash. Furthermore, where Dr. Kale disclosed to the applicant that he loved the warmth and particular colour of the honey ash wood. Regardless of whether Dr. Kale's reasoning for the selection of particular wood was explicitly written in the contract, it is still regarded as a key term. This is because it was clearly expressed before the contract to TED Constructions that this was the reasoning why Dr. Kale had chosen this wood to begin with and was the basis of the contract being formed. Therefore, through the previous dealings between the parties, it remains clear that the promise is sufficiently obvious and necessary to the effective operation of the contract. The term is not inconsistent with the parties' intentions, therefore the applicant, as a reasonable person, should have known that the term was intended to be a term of the contract, and without the completion of this term, therefore action for a breach can be brought. Your Honour, it follows in my submission that the performance of a contract in alliance to its terms is one of the ways a party can be discharged from further performance of a contract. For a party to be discharged from a contract, there must be an evaluation of exact performance and careful consideration of contract terms. Seeing as the contract is for the sale of goods, this means that the obligations of the contract are dependent on those obligations being completed. Therefore, the defendant, Dr. Kale, is dependent on the performance of the applicant, Tedwood Constructions, to complete installing genuine honey ash wood that obtain the specific qualities that Dr. Kale disclosed before he is obligated to pay his installation. Your Honour, as it follows in the matter of the 1795 English contract law case of Cutter v. Powell, a leading case in this area, it likewise establishes the requirement of the plaintiff's contractual obligations being completed before the defendant is obligated to complete theirs. In this case, a seaman agreed to work on a ship making a voyage from Jamaica to Liverpool, where the defendant agreed to pay him 30 guineas upon arrival. The voyage took 6 months, but Cutter died 6 weeks into the voyage. Cutter's administrative commenced action to obtain the contract price. However, it was held that because it was indicated in the contract that Cutter was required to complete his duty for the whole of the voyage and therefore his obligation of performance was entire, he was therefore only entitled to payment if he had completed the voyage. Evidentially, this case underlines that the condition of the contract must be performed by the other party before the other party is entitled to receive anything under it. This is because the contract price is payable for the actual goods, not the willingness to deliver these goods. Therefore, if the goods and services are not provided, the other party's obligation to pay the price does not arise. Your Honour, a further consequence of the obligations being dependent is that if a buyer refuses to accept the goods when delivered, the seller will only be able to claim damages, not the full price of the contract like Tedwood Constructions has. In that being the case, it cannot be suggested that my client, Dr. Kale, has breached the contract. The matter of this case is that Tedwood Constructions did not deliver the goods in accordance to the contract. In addition, on the basis of the applicant's failure to perform the contract according to its terms, it is a breach of the contract. In my submission, the applicant must fail entirely and no compensation should be paid. Unless I may assist you all further, those are my submissions.